My name is Jennifer Tharrington, and I'm a partner at the law firm of Haas & Associates. Our website can be found at www.carolinafamilylaw.com. This presentation is called Gestational Surrogacy 201. It's a follow-up presentation to another video that can be found on this website, Gestational Surrogacy 101. This presentation takes the conversation about gestational surrogacy a little bit further and goes through some of the aspects of the Gestational Carrier Agreement. Because I'm an attorney, I have to, of course, start with a disclaimer that says that nothing in this presentation is intended to give medical, psychological, or legal advice, and that viewing this presentation does not create an attorney-client relationship. Every situation is different, and you should consult an assisted reproduction law attorney with the specific facts of your situation to make sure that you get the best possible legal advice. The first question I'm going to cover in this presentation is, what should you look for in a gestational carrier? This information is intended for couples that are utilizing a gestational carrier match that was not found through an agency. If you're using a gestational carrier match that was found through an agency, the agency will likely have certain criteria that they require for all gestational carrier candidates to be members of their portfolio. If you're not using an agency and you're using a program provided through your IVF clinic, or you're looking for a gestational carrier on your own, here are some things you should look for in the right candidate. She should be at least 18 years of age or older, and some agencies actually require that she be 21 years of age or older. She should be married or in a stable, committed relationship with a partner that supports her decision to be a gestational carrier. She should have had and be raising at least one child of her own from an uncomplicated pregnancy. And you can consult with your physician to determine what the definition of an uncomplicated pregnancy should be. She should be in good physical and mental health, and this often means that her body mass index should not be too high. She should have had prior uncomplicated pregnancies, and she should not be taking antidepressant or other psychotropic medications. She should be satisfied with her own family and ideally does not wish to have additional children of her own. She should be comfortable with the sexual orientation and religion of the intended parents. She should have health insurance or be able to easily obtain health insurance as well as access to quality health care. She should have compatible views with the intended parents on the issues of abortion and reduction. Reduction is a situation in which a carrier may be carrying multiple fetuses, and for certain reasons, one or more of the fetuses will actually be removed during the pregnancy. Most of the time, a person's views on abortion are similar or identical to their views on reduction, but it's very important that the carrier's views on abortion and reduction are compatible with the views of the intended parents on those very serious issues. She should not be on public assistance or in a financial crisis, and she should not have a criminal history, particularly in the areas of financial crimes like extortion or fraud, child abuse crimes, prostitution, or drug-related offenses. Most importantly, and this is what I tell my clients all the time, the relationship between intended parents and their gestational carrier is extremely unique and sensitive, and it should be built on mutual trust and compatibility. If something about your gestational carrier just doesn't feel right, you should talk with your physician, with your psychologist, and with an attorney to make sure that going forward is the best idea. The next popular question that I get asked is, what exactly goes into a gestational carrier agreement? The contract is a comprehensive document that covers all aspects of the gestational carrier arrangement and sets out the rights and obligations of each party both before, during, and after the pregnancy. This assists everybody going forward in making conversations less awkward, and it also gives a framework for certain discussions that you may have with your gestational carrier, so you kind of know what questions to ask and what answers to seek in determining whether she's the right match. Topics covered in a gestational carrier agreement include, but are not limited to, the parental rights of the intended parents and the lack of parental rights in the carrier and her spouse, the way the embryos will be created and the conditions under which they will be implanted. This usually covers the number of embryos that may be implanted in any one embryo transfer, as well as the number of transfer attempts that may be made prior to a party deciding that the contract or the arrangement is not working out. The conduct of the carrier during the pregnancy. This can include routine visits, specialist visits, dietary or travel restrictions, basically anything that the carrier and the intended parents agree is in everybody's best interests to maintain a successful and healthy pregnancy. The location and conditions of the delivery, abortion and reduction decisions, medical history of the carrier, presence of the intended parents at OB appointments as well as at the delivery itself, medical decision-making and authority over the fetus as well as over the child after the child is born, what will happen in the event of death or divorce of the carrier and her spouse or of the intended parents, compensation and payment of expenses related to the pregnancy, and future contact and relationship between the parties. So how does the compensation part work? The buying and selling of biological material, of parental rights, or of children is illegal in North Carolina and on the federal level. So the surrogacy contract makes it very clear that that is not what's happening in a gestational carrier arrangement. Instead, the contract clarifies that the carrier is going to be compensated or reimbursed for her pain, suffering, and discomfort that she experiences during the pregnancy, and that the money that changes hands between the intended parents and the carrier can also be viewed as pre-birth child support. So essentially, the intended parents are acting as parents and supporting their child even before he or she is born. So the next question is, how much does this usually cost? And this is one of the most popular questions that I get asked by intended parents. The cost or the compensation that's usually paid to a gestational carrier varies state by state, but in North Carolina, the range is roughly $22,000 to $40,000 as the base compensation. The base compensation is usually paid out in monthly installments throughout the pregnancy. In addition to the base compensation, carriers may also receive a number of other stipends and reimbursements throughout the pregnancy. These include, but are not limited to, an injectable medication fee, an embryo transfer fee, an invasive procedure fee, a maternity clothing allowance, an additional fee for carrying multiple fetuses, an additional fee in the event of a C-section, an additional fee in the event of a termination or reduction, the coverage of unreimbursed medical expenses, the payment of health insurance premiums, the payment of life insurance premiums, a non-accountable monthly allowance to cover incidentals during the pregnancy like prenatal vitamins, long-distance travel reimbursement, local mileage reimbursement, a bed rest stipend in the event that the carrier is placed on a physician-ordered bed rest. This can include childcare and/or housekeeping stipends, lost wages reimbursement for the gestational carrier in the event that she's ordered onto bed rest, as well as in the event or surrounding the time of the delivery, reimbursement for mental health counseling, and attorney's fees. So after hearing such a daunting list of possible issues, reimbursements, stipends, etc., a lot of intended parents, and some gestational carriers as well, often ask me, if I trust my gestational carrier or I trust my intended parents, why do I need a contract at all? The answer to that question is simple. There's no law in North Carolina to guide us regarding gestational carrier arrangements or surrogacy. This means that in the event of a dispute, the judge has no statute book that he or she can open to look at the law to help him or her decide what the best resolution should be. So instead we provide a contract. And our hope is that the judge would read this contract that sets out the intentions, the rights, and the obligations of each party and helps the judge decide on the correct outcome. Most importantly, the contract protects and memorializes the intent that the intended parents be the parents with all parental rights and obligations, and that the gestational carrier and her spouse are not the parents and have no parental rights or obligations to the child.